The dust is yet to settle following the efforts of the Economic and Financial Crimes Commission, EFCC, to arrest the immediate past governor of Kogi State, Yahaya Bello, on the heels of anti-graft agencies' preparation to prosecute him over corruption charges. Despite the heavy presence of the EFCC operatives around Bello's residence, its successor in office, Usman Ododo, paid him a solidarity visit and drove to his residence in the afternoon and was chaired by loyalists of the former governor who were present to support the embattled principal. While the siege on Bello's residence was still on, two conflicting court rulings emerged in an attempt to arrest the former governor by the EFCC. One of the rulings from a Kogi State High Court sitting in Lokoja restrained the EFCC from arresting or detaining or persecuting Bello. So joining us now is Onikepo Braithwaite, a lawyer and this day legal editor. And great to have you on the show. I mean, we review most of your back page almost every time, and we still talked about your insight yesterday. Great to have you. But let us understand the loss that is happening with it. Yahaya Bello's argument is, they didn't send an official invitation, the way they are going about it. He went to Kogi High Court to say, you know what, based on my right, if I feel I'm going to be persecuted in an unjust way, I should be able to defend my right, and the court ruled against him. But you have another counter by saying that the case had already even been in court in the first place before he, went to court as regards that, and which judge granted. I mean, just take us through all of this. Then we'll talk about that, then we'll talk about jurisdiction and other things.
Good morning. Thank you for inviting me, and good morning, Nigerians. The procedure for arresting a person who is reasonably suspected to have committed a crime, is provided in Section 35, Subsection 1C of the Constitution, and Administration of Criminal Justice Act. And in this case, since it's the EFCC Act. Now, Section 35, 1C of the Constitution says that if a person is reasonably suspected to have committed a crime, he can be arrested. So that is one of the reasons why an exception to the guarantee to your right to liberty, if you are reasonably suspected of committing a crime. Section 3 of the Administration of Justice Act says that a person can be, if you are a suspect or you are a defendant that you've been charged to court, you can be arrested for investigation and the rest of it. And then the EFCC Act, Section 6, also says that the EFCC has the right to investigate, arrest, investigate those that it suspects and identify whoever they feel has committed a financial crime. So first of all, this issue of saying that you were invited or you were not invited or you have to be invited, I don't quite understand. What the Constitution says is that once there's that reasonable suspicion, you can be arrested. In this case, it seems as if it appears that charges had even already been filed against Yahaya Bello, even before he went to the Kogi High Court to get the interim order. So I think they're within their rights. Section 3 of ACJA, the Criminal Justice Act, says that either you're a suspect or you're a defendant that has been charged, you can be arrested. Now, there's nothing in any law that says you have to be invited. What the law says is that if you are caught committing an offense, then they don't need to tell you because you're caught in the act or you're escaping from the scene. If not, if you're arrested within 24 hours, you must be notified as to the grounds of your arrest. And it's unlawful. I think if I were me against Inspector General of Police, it's unlawful to make an arrest without having sufficient evidence to kind of ground your charge or, I just say, Ruben, I'm arresting you. You can't. There must be something. So I don't, in terms of him being arrested or no arrested or whatever it is, I can't really see where EFCC has gone wrong so far in this case. Now, he had already been charged. And I think on February 5th, 2024, they tried to amend those charges at the Federal High Court. And then on February 9th, he went to the Kogi High Court to obtain an interim order that he shouldn't be arrested, etc., pending him, his family, his staff, appointees, blah, 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 pending the hearing of the motion, the originating motion. But, for me, that looks like an abuse of court process because the matter was already before the Federal High Court. So why did he not go there?
Okay, let's break it down.
Yes.
There are persons who have also argued that
Yes.
there's a difference between court summons,
Yes.
right, and also EFCC invitation.
Yes.
EFCC has its own procedures.
Yes.
And there have been precedents in that regard.
Yes.
And counsel to Yahaya Bello have been arguing that, look, it looks like they abbreviated the process with regard to the Yahaya Bello case. And that Yahaya Bello, what all he has done is to go to court to seek the enforcement of his fundamental human rights. But I read your piece this morning where you said Yahaya Bello is making a mockery of the law.
Yes.
And you made a point in your opening paragraph that nobody is above the law.
Yes.
Which is a basic principle.
Yes.
Even if you find cases where people are being treated as if they are more important than others. But can you speak directly to the point about how you feel that Yahaya Bello is making a mockery of the law and he and his counsel do not need to seek for enforcement of fundamental human rights? Because that's the plank of the argument of his counsel.
Look, first of all, making a mockery of the law in the sense that you don't need an invitation. So, you don't need, there's no law. I've searched ACTA, I've searched EFCC Act, I've searched the Constitution. So you don't need, so if EFCC chooses to invite you or whatever, it is fine. But they're not breaching any law by not extending a formal invitation to you to say, come. And, they're making a mountain out of it. That's number one. Then, the fact that, in fact, this morning I was told that he's going to file defamation charges for the defamation suit.
With regard to the American International School, payment of school fees?
No, for the charges against him.
Oh,
and
okay.
Again, the law that I know, when you are charged to court, you go, you are arraigned, you plead guilty or not guilty, and then the trial begins. The burden of proof is on the prosecution to prove the case beyond reasonable doubt. And if they don't, you will be acquitted. If they do, you will be convicted. So I am not aware of a process that the answer to criminal charges is that you say you are going to file defamatory suits against whoever.
The prosecutor.
Yes. Then, they're just all sorts of, I just look at it as, different things that he's just trying to escape and evade justice. Going to hide in the State House or wherever they said he is. Section 308 of the Constitution only gives the president, vice president, governor and deputy governor immunity from suit and legal process while they're in office. I'm more sure that it gives the building immunity.
Immunity is for the person.
Is for the person. So if you go and hide, I don't know why, the law enforcement cannot go there to go and do whatever, because it's the law says that Section 3 of the Criminal Justice Act says you shall be arrested as a suspect or a defendant that has been charged. And I think that both of those conditions have been fulfilled in this case. So going to hide, I don't also understand that, because the immunity is not for the building, it's for the person.
Or does it extend beyond
Yes.
the tenure in office
Yes.
of the affected officer?
Exactly.
So what will be your advice to former Governor Yahaya Bello?
If he was my client, I would have told him to give himself up, answer the charges. If they detain you, and then also making a mockery, what rights have been violated? It can't be preemptive. So if you arrest me, for instance, and you keep me longer than the number of days the law allows you to keep me in detention, then I can enforce my, to enforce my rights. You have not been even arrested. It's not as if your rights have not been. Do you understand what I'm saying? So I really don't know what rights he's enforcing. Usually, you can't build something on nothing, really.
Basic principle.
So if he was my client, I wouldn't even have let it come to this. I would have said, oh no, go to EFCC. And of course he knew. So EFCC didn't send him an invitation card. But I was watching this show yesterday when Ayo said that the court processes showed, it alluded to the fact that Yahaya Bello was quite aware that the EFCC wanted to see him. I know he was aware that they wanted to see him. So I would have gone with him as his lawyer for him to be interrogated because he has a right to legal representation. And, we take their questions and write our statement. And if they said they were going to detain him, ask for administrative bail.
Yeah.
Every offense is bailable, even murder. The only thing about murder is that you have to go to high court to get your bail there. You can't get bail from police station.
So the bone of contention, some people are sort of like surrogates to him when they came yesterday. Yes. What they were saying was the EFCC chairman should be, they brought him before a court for contempt of court. I mean, what would you say about that? The EFCC chairman in this regard?
I don't know.
That's at the Kogi State
High Court, yeah.
But you know that the Kogi is forum shopping. Because in the first place, assuming without conceding that Yahaya Bello actually, maybe his rights had been breached. Now, Section 46(1) of the Constitution and Section 251, Subsection 1R of the Constitution, there are two provisions on fundamental rights. I think one of them says that if your rights are breached or likely to be breached within that state that you are, you can go to the High Court to, enforce those rights. Then Section 251, Subsection 1R says that where a government agency is involved in the matter, that the Federal High Court has exclusive jurisdiction. Now, there are cases that say they have concurrent jurisdiction, either Federal High Court or State High Court. But in this case, since charges have already been filed against you in the Federal High Court, why didn't you go there to enforce the rights?
There's some cases that say you have concurrent jurisdiction. Probably he went to pick the lesser evil where he had
it's forum shopping.
Influence.
No, it's forum shopping. What I'm saying is that if the charges have already been filed against you in one court, so why didn't you go to that court, which is the one that is to enforce your rights?
Which leads me to the next question, which is about the complicity of the judiciary.
Yes.
You were at the National Justice Sector Reform Summit.
Yes.
And you mentioned it in your column too.
Yes.
About the independence of the judiciary. And there have been a couple of articles out there.
Yes.
How the judiciary is complicit.
Yes.
Even when you talk about forum shopping.
Yes.
And it's not even forum shopping. How about the lawyers themselves who seem to manipulate the law? Maybe the NBA needs to do more.
Yes.
So when you blame a litigant, how about the lawyers themselves?
You're right.
How about the judges themselves?
You're right.
So can you address all of these issues from the angle of the judicial process, from litigant to lawyer to the judges?
At the summit, in the communique, one of the things that was said there, I think it was the Senate president and some other people, that the NJC should come down hard on erring judicial officers that allow themselves to be used for, abuse of court process, forum shopping, and what have you. And, for the lawyers, the LPDC, the disciplinary committee or whatever, maybe they need to be more up and doing. I mean, when we look at, take for example, when we looked at election petitions, for instance, the other day, when they said, in our publication, every week we have a law report page. So they sent me a law report one week, and I think it had to do with membership and sponsorship of political parties or something from one of the cases from the last election. So we reported it. The next week, they sent me another one. So I was about saying, why are you sending me the same? You sent me last week. The only difference was that when I looked at it more closely, I saw that the difference was that maybe one was Labour Party, one was another party, but it was on the same subject matter. And I said to myself, when are we going to get to a point where before you would advise your lawyer that, based on this case, or based on the facts of this case, you cannot win on this. The point I'm trying to make is that there are issues that unless the law changes, the judgment is not going to change. If it changes, it's going to be perverse because the authorities are there.
Precedent.
Yes. So we need, so even we as lawyers, going to court to try things that we know will not fly.
No, on that, I'm sorry to comment. The reason why lawyers will try things is because they get away with it.
That is the
truth point. Is, some of these judges are complicit. And I'm sorry, the law changes. I mean, you were talking about election petition.
Yes.
Look at some landmark rule. Look at the case of Kano. At the going up to the highest court that determined that case. Look at how the judgment changed. Look at the case of how judges, when there was so much attack on them, had to start going to defend their judgment in public forums. So the law does change in this country. It depends on who the law is changing in favor of.
No, the point I'm making is that in the issue of the membership and sponsorship issues, the Electoral Act is quite clear. So I'm saying that we know it is clear. So unless that provision is changed, the result will always be the same. So why do you bother to go and waste the court's time ventilating?
The law is the law.
Yes,
I get your point about discipline.
Yes, so sanctions, but because there are no serious sanctions.
Well, recently, at least the Legal Privileges and Disciplinary Committee just sanctioned one lawyer, in some other infraction.
Yes.
But how about the judges themselves?
No, well, that's for the
National Judicial Council. But do you think that the judges are also complicit?
Of course. And, it's part of what we discussed at the summit, things about appointment of judges, meritocracy, and things like that. It can't just be that...
Oh, so people who do not merit position end up on the bench?
No, well, I don't know. It's opaque. I don't know how they choose them. You know what I mean? I really don't know. But, people
based
have argued...
No,
well, there's nothing wrong. My father is a lawyer. So is my mother. My father is an economist. So am I. So I studied the same thing. There's absolutely nothing wrong in towing the path that your parents have towed.
No, but
when you merit it. So if my father was a judge and I merit it, why can't I become a judge?
There are people that they'll say they've not grown up the rank, that they don't merit it because somebody that is close to them is on there. Look at Chidi Ondekalu's article, and he stated it very clearly. A lot of people that have been put through the legal system high up there, and is questioning how much they even merit this, but because they have somebody who internally.
So I part of what some lawyers have said is that make the criteria transparent. Let us know what is required, to be able to become a judicial. There's nothing wrong. So I can't be a lawyer. My brother is a lawyer too. I have only one sibling, so we're all lawyers. So does that mean that because my parents are lawyers, we can't study law or we can't toe the same line? No. But you have to be merited. So if it is exams or whatever, or okay, you say a lawyer of 10 years standing. if I've had a restaurant for 10 years since my call to the bar, or, you know what I mean, I'm a disc jockey or whatever it is.
Or you are emceeing all over
Exactly.
town.
Do you understand? And I have absolutely no... So I have that 10 years post-call, and I'm even paying my practicing fee. I'm the first one there on January 1st I pay. But I don't have any experience. So, you know, some of these things...
Or you are a political appointee forever.
Exactly.
And then
you know,
you want to become an
it should be more than that.
So, and let's talk about that. So why is it that things like that are also at the discretion of some people? I mean, that's a big question out there. You look at some people that don't really merit things like,
Yes.
you know, positions
Yes.
like that.
Yes.
And they're given,
Yes.
while some that merit
Yes.
are not. I mean, the SAN thing, for instance, there's been a lot of complaint.
Yeah, it's a matter of privilege.
So why should we have that level of privilege that is not defined?
Well, I don't really want to...
It's a matter of privilege.
I don't really want to comment on that because I don't know how the LPPC works and how. So these things are opaque. Even though the law says, oh, if you have this, that, then you can qualify to be SAN. In fact, one of my columnists, Michael Zekome, has written that once you fulfill the requirements, then why not?
Okay, let's talk about what do you think is next in the Yahaya Bello case versus EFCC? Because the whole thing has become a circus. What do you think is next? There are matters to be determined May 10 and all of that in the Court of Justice Emeka Nwite. What are we likely to see next? It's a perpetually developing story.
Well, I don't know, but I think that all the side cases, maybe the one for contempt of they are all side distractions.
But the main case is in the Court of Justice
away from the fact that there are 19 weighty charges against Yahaya Bello. 11 of them, the EFCC, the charges allege that he's bought properties in Abuja, in Maitama, in this place and that place, even United Arab Emirates. Those are weighty charges that, you know, punishment under Section 15 or so of the Money Laundering Act is between 7 to 14 years. So whether they take the EFCC chairman for contempt or not doesn't take away from the fact that those charges are there. If I was his lawyer, by now I would have quit. Because if I would have...
You will appoint another lawyer.
Yes, but by now I would have quit. That if you have been invited, or if you have a case and the law enforcement agency wants you to come, other people have gone. Did they die? You know, so you go and answer whatever it is, make your statement and all that. If they hold you, we know what to do. There's a legal process to get your bail or whatever it is. So I would have advised him to go.
Let's talk about civil societies and those you call television lawyers that have come to turn the law over its head. I mean, civil society, for instance, we've seen some civil society groups say that even putting out details of the children that their school fees was being paid was a violation of the rights of the children and all of that. Yesterday, in front of the EFCC headquarters, there was a brawl among some youth groups, you know, fighting with each other, pro and against, you know, Yahaya Bello and all of that. Let's talk about all of that shenanigan happening.
I mean, a lot of these things to me look as if they are sponsored. You know what I mean? A lot of it looks to me as if they're sponsored. If they say that you used 840,000 or whatever it is dollars of state money, you know, to pay your children's school fees, and you did not, you defend it in court. You know, the school itself has its own different issues, charging in dollars and all that, because there's also punishment for even institutions that also breach the Money Laundering Act and things like that. You know, so charging in dollars and all that, they also have their own whatever it is. But the point is that face the charges. For me, when I even looked at that $840,000 that is alleged, because we don't know until they hear the case and it is decided, I said, do you know how many classrooms can be
built
in Kogi State with that amount of money. So all these people saying, they're just trying to take away from the issue. That it is within the law, if you have evidence, to arrest a person and to charge them to court. And you will go, you try the matter, they defend themselves, the court decides. And there are tiers of appeal. You go to when the Federal High Court finishes, you go to the Court of Appeal, and then you go to the Supreme Court, the final arbiter, whatever it is. So I think that a lot of these things, they're just trying to sort of distract, let us take our eyes off the ball.
Okay, I see you are a constitutional purist.
Yes.
The law is the law. The law is what the what the lawgiver says it is.
Yes.
Augustinian positivism. But do you think, as some people have argued in this case, that there is politics to it? I know you say politics is not law, but are there dimensions of this matter that are political?
I don't know. I'm not a politician, but I read the charges, and they didn't look political to me. You were charged with the criminal breach of trust, taking $550,000 of 550 million naira to buy a house in Wuse. Those are clear charges that you either say, no, I didn't buy it, come and prove how you said I dipped into the treasury to buy it. I don't really see what politics are in those charges. Those are straight charges.
No, but in Nigeria, people say, you get charged if you have stepped on the wrong toes.
No, everybody says...
If you have committed some... if you have issues, some political issues with some people,
yes,
that's when the law remembers you.
Yes.
But when you are on the right side of the politics, nobody bothers.
So does that mean that, throwing that back to you, so does that mean that we should continue like that?
No, I'm just reporting to you other dimensions of the story.
Well,
I'm not expressing an opinion.
Well, I'm a lawyer. I go on evidence and what I see. In fact, when I was telling a friend of mine, a son, that I was coming here, he was, are you going to come? Are you sure? Rules of professional conduct. So I said, Section 33 of the Rules of Professional Conduct says that I can come and discuss the case. I'm not a lawyer in Yahaya Bello's case. My law firm is not in Yahaya. So I can come and... Even a lawyer in the case can, as long as you don't say things that are...
Sub judice?
No, as long as you don't say prejudicial or that is going to, that is prejudicial to the case. So I can say, but, I don't do speculation. I do law and evidence and facts. So I don't know whether it is political or it is not political, but I saw 19 weighty charges. 11 of them have to do with allegations of purchasing properties in different places, including United Arab Emirates, based on criminal breach of trust, meaning that maybe you dipped into the treasury or use your state money to whatever. And it's actually quite interesting that the man himself, I don't think they've paid the allowances that they're supposed to have paid to the deputy governor that was impeached. So they don't obey court orders. But when it comes to them, then they start to enforce non-existent rights, Because even in that case, the deputy governor, I think his name is Mr. Achuba. Yes, he came out to say something about some money that he didn't like the way the money was spent or something, and that civil servants in Kogi State had not been paid their salaries for 38 months. Maybe they fell out. Next thing, they set up a panel to impeach him. Now, the law says that if there's no wrongdoing found against you, by operation of law, those proceedings end, and there's no talk of removal or whatever. This man, the panel found him not guilty. But Kogi State House of Assembly at the time under Yahaya Bello went ahead to remove him.
I mean, we all know how House of Assemblies work in the country. You're always under the governor. It's whatever the governor wants, he gets
Okay,
it. Which
thank
doesn't
you
make
very
it right.
much, Onikepo Braithwaite, this day legal editor. Thank you for your perspectives. Thank you for joining us on the morning show.
Thank you very
we
much.
hope you will come again and again.
Well, I'm not sure about that.